the next panel or the one after that. And welcome back. You know how to do this, and you don't need to get close to the mic, but I don't have to remind you of that. You're welcome to. Introduce yourself for the record. Give us your testimony.
Thanks. I got that first sergeant voice. My name is CJ I'm here in opposition to SB14 on my own behalf because as a civil rights attorney, SB14 is perhaps one of the most dangerous bills I've seen since I began coming to the Capitol and advocating for and against legislation. SB14 should be named the Protect Bad Cops and Let the People Eat Cake Act. I feel this body needs to be reminded that Article 1, Section 2 of our Constitution says that, quote, all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit, not the benefit of government agents who violate that trust that we, the people, placed in them. I'm a retired special agent, federal agent. I've got my retired credentials here. I've got my TCOL certification, so I'm not anti-cop. As my website suggests, ISueBadCops.com, that's what I do. I sue bad cops. This is going to protect bad cops. It's going to make it harder. As a civil rights attorney, I can't tell you how many times I've got somebody that comes to me and they want to file a lawsuit, and I can't access through open records, okay, well, has this officer done this before? Because as we all know, the police investigate themselves and find no wrongdoing. This happens more often than not. And they want to protect this. Good cops are not afraid of having their records exposed on discipline, attendance. You know what, if my cops that I pay for taxpayers aren't showing up to work, I deserve to know they're not showing up for work. If they're taking extra vacation, I deserve to know that they're taking extra vacation. I don't need to know their addresses and their social media and their private information. I'm talking about when they're on the clock. And it is difficult as a civil rights attorney, as it is under the current law, to be able to get information. And it forces people like Mr. McCain here to pay thousands of dollars to an attorney to find out what we should be able to get anyway. We're moving in the wrong direction. 552 covers up way too much. This is going to cover up even more, and we need to be more open and transparent with how our law enforcement act and not hide stuff. Good cops aren't afraid of sunshine, and I ask you to vote against this bill.
Thank you for your testimony. Senator Perry, you have the panel.
Thank you, Mr. Chair, and I'm not sure this is why I wanted the resource witness to hang around. It may be more appropriate. She had laid out kind of how we got here, but not actually what the bill did. And my recollection and the origin of this conversation has gone on for a long time if it's the same concept. So I'm going to ask the gentleman in uniform there, the officer, and if you're not comfortable or you can't explain it, it's not going to hurt my feelings because you would be one of several, I'm afraid, that we're going to find out that can explain it. And maybe I'm wrong on the background, but this started kind of as an employment issue several sessions ago, and it'd been ongoing. I remember I've been here 15 years. It was old conversations, and I'm going to reference things, and if they're not applicable, to say this doesn't have anything to do with it. I remember there was something referred to as a G file. Is that relevant to this conversation?
Yes.
Okay. And the origin or the conversation that ensued back when I was looking at this, because we had some bad police people. They're human, right? We get good ones and we get great ones, and then we get one or two bad ones. And what we found was no different than our school systems, et cetera. We're, quote, passing the trash. And so we opened up the G file as a required conversation between one department and the next when they were looking at hiring someone. So that if you're a bad guy here, that G file was absolutely required for the person talking about hiring you so that we would stop passing the trash. So with that as a background, is this the G file that we're talking about prohibiting from public disclosures? And if it is, great. If it's not, and then I'll probably have a conversation for CJ to follow up on. But is it that file?
From my understanding, this is the file that contains allegations of misconduct or any other information that is not substantiated, the exonerated, false reports, such information such as that is prohibited from public release.
So what I hear you saying is we don't have a problem going after bad cops with full disclosure, but what we don't want to do is go full disclosure of something that has not been vetted and proved.
Yes.
All right. CJ,
So here's the problem with that. It sounds good, and that would be great if that's how it worked. But what happens is a police officer gets accused of misconduct. Rather than go through the process of an investigation, that police officer resigns. Guess what the police department does? And these are cases I've had. The department drops any substantiated or any investigation because the person no longer works there. So once that officer quits because he's been accused of doing something, the department no longer investigates it, and it's unsubstantiated. But the people deserve to know if I'm the fifth, the sixth, the first person who was accused this officer of something. I know it's just an accusation, and as an attorney, I will look at that as only an accusation. But when you start seeing patterns, that's what we're looking for. That's what people want to know about is, are there patterns? And if this guy's getting accused of something and then he quits so he doesn't get investigated, so he doesn't get into the G file, and then he goes to another police department, and that police department doesn't see anything because there's no, that's what we're talking about.
so back to the officer. There's an F form. There was some form. What was it, F something?
Something like that. I don't remember.
So on that form, there was very general, let's just say very nondescript reasons for termination or retirements or whatever that is. So has that form been modified to be more detailed?
So yes, at the end of an officer's exit of employment, we're required to finish all pending investigations to complete this. And that's part of us adopting that TCOL model policy on misconduct. So once we complete all those, all that information is sent to TCOL.
With or without, so if I did something and I quit, does the form reflect a full investigation even after I quit?
Yes.
So the concern that you're a bad guy, you quit so that it won't get out and you'll go to the next place and there'll be no record of it is not true
Right.
under today's reforms.
Under today's reforms that were just active a month ago.
Okay, so I'll go back to CJ a minute. Couple of questions.
Yes.
There's this really fine line, and this came up through a trial lawyer's bill during session, and after I understood the context, it made sense to me, and it was the trucker's bill. And effectively, the first stage was whereby I would just call smart lawyering. They would bring in previous information into the first stage that would prejudice or bias the jury. And once they made their case at that level, then they would go into award damages. Well, the whole law was about taking the prejudice of a historical context off the table and look at that individual on that instant and that issue. And I use the example, right, wrong, or indifferent. If I'm a murderer 20 years ago and I served my time, did my crime, and I walked out on the streets today under a justice system, and then I got called in for something else, it's the something else that I should be tried on first, and then if I'm found guilty of that, then I should be punished accordingly with all the back history. So what concerns me in what you're saying is, one, if it's never been vindicated, but there is a documentation of the final investigation, be it internal, but I have to trust internal affairs and people at that point that are delegated that responsibility, that if that was a public disclosure that you bias or taint or possibly prejudiced before that person was actually dealt with on the issue of the present. So is ultimately all that stuff, if you were to go to a court, is all that stuff going to be discoverable and pulled out anyway once you've done your job as an attorney?
So yeah, that's where the difference is, where right now, if I want to get that information as an attorney for my client, I can do that if I file a lawsuit and then in the discovery process that my client's going to be paying for. What we're talking about, and I don't know if the new legislation that hasn't gone into effect yet is going to fix some of these problems, like as was just discussed, but I can tell you right now that the here's the thing. I've been arrested 5 times. That's why I became an attorney late in life.
I know your
I'm tired
story.
of being arrested falsely. But you know what? If you go and you look it up, you're going to see 5 arrests from CJ, even though CJ never got convicted. Why? And that's good for me, because that shows that I'm not a lawbreaker, that my charges were dismissed. I would think it would be a good thing, whether charges or claims against an officer, if they were dismissed as unfounded, I'd want to know that as an attorney, because if a client came to me and I did my pre-litigation work through an open records request and found out, well, this guy's been accused, but he hasn't done anything wrong. I just don't see where we can do it. That's a good thing. It helps the officer to show that, hey, I'm clear, I'm good, but we want to hide that. And it's not just the bad, but it's also the good. And the people, the citizens who pay that salary and for him to do those services, again, we deserve to know, because what if there's been 12 different claims from 12 different people in 12 different areas that have all said the same thing about this officer, but yet for some reason that corrupt police chief keeps finding no wrongdoing. Sometimes where there's smoke, there's fire. Sure. But we won't know that with this bill.
So, Mr. Chair, when the members are through with this group, I do want the resource to come back and clear up current law that we passed that you said went in effect a month ago.
Yeah, it's just
Okay.
June 1st.
Thank you.
Thank you, Senator Perry. Senator Schwartner, you have the panel.
Thank you. On the lines of Senator Perry's questioning, there is concern that I have regarding pass the trash, whether it's regarding our educators or our police officers. In Williamson County, we had the Michael Morden case in which exculpatory evidence was hidden by the sheriff and DA a long time ago, and he served a long time in jail before he was released. We also had an unfortunate incident with a prior sheriff as well, Sheriff Chody. I think you actually referenced that. But I have some concern that this bill, which, if I'm reading it correctly, allows for the creation of a confidential department file to be produced and maintained if there was insufficient evidence of a misconduct, of an alleged misconduct. And on the surface, that seems okay, but as I think Senator Perry was saying, a chief that's befriended somebody that is a subordinate could continue to hide wrongful action. And then, if I remember correctly, when TCLOS went through sunset, and hopefully someone on this panel can help out with this, the chief of that department, whether it's a sheriff's department or a municipal police officer's department, has to sign some sort of form. Is it a pink form, blue form, something before their L5, yeah, something like that. And so I want some clarification as to how this confidential file fits in with their L5.
I think it's an F5. I think it's an L5.
L5.
The resource witness.
The resource witness can help us with that? Yeah. All right. Well, am I, CJ, I guess, you're an attorney, prior police officer?
A federal agent.
Federal agent.
I did national security.
Am I thinking incorrectly that this could be a way in which bad cops can be passed on and are hidden from being properly overseen, and any misconduct found out that they are perpetrating on a repetitive basis against citizens?
And like I said, and by the way, I represent good cops too, by the way. I don't just sue bad cops, but I represent good cops. But I'm more concerned really what this does in a lot of the smaller towns where all the cops know each other and they're all buddy-buddy, and guess who the IA is? It's their buddies. But yes, I literally had, and I don't want to call out anybody, but I literally had a department tell me that, well, we dropped the investigation because he resigned. So there was no investigation done. I couldn't find out whether it was substantiated or not substantiated. I have to go off my client's word, which that's why I always tell my clients, record everything, because sometimes it's
this gentleman here, this officer, said that all those investigations get completed. Is that wrong?
As of a month ago. With the TCO model policy requires us to complete all investigations upon employee's exit.
Well, and what I would say to that, I understand where he's coming from. I am in no way demeaning his integrity on this, but I doubt he follows every single department, whether it's an ISD police department, a city officer, the counties, the constables. And we have laws on the books already, but guess what? They get broken. I gave you 2 pages of of police officers just in the last couple of years who have been arrested for very serious crimes. So just the fact that we've got that, that's not what's happening in practice. And by covering up even more, we're just making it easier for them to cover it up. And it's already being covered up.
If I may jump in just real quick on this, because I don't have a lot of experience with Texas law enforcement, but in other larger cities like New York, I have family who was affected in certain cases like this. A lot of the times, whether it's law enforcement unions or different precincts or chiefs who are buddy and buddy, there'll be these officers who do have these allegations and they're ongoing investigations, but then they are transferred, so then the ongoing information doesn't get passed along until that is wrapped up, and then these other precincts will draw out that investigation so that the people don't get the info. It's an ongoing investigation. We're still looking in, well, it's been 4 months and this happened 8 months ago and we're trying to start our trial on this issue. So when it comes to those kinds of things.
Thank you. It's a difficult issue because I think police officers are probably repetitively and wrongly subjected to misconduct allegations, especially in this day and age. And how do we handle that as a state regarding the allowance of a separate personnel file for unquote unsubstantiated, insufficient evidence type of allegations versus substantiated and true allegations are ones that should have been at least evaluated fully. So it's interesting. We need to ask more questions. I agree.
Thank you, Senator Swardner. Senator Perry, you're recognized.
So the resource witness, I hope, is going to clear this up. History with the agency, maybe not. CJ, one question, quick and easy. You have a client. You, under the old law, subpoena the records, freedom of information, and you get a list of 20 different times this person's been written up. All either ultimately dealt with and no problems, or 20 of a correct record you can't tell because, quote, quit one 15th and then did it again. But here's the question. I don't have the answer. Is there anything to keep CJ Grisham from making that information public before you file a lawsuit?
Currently, yes. I'm sorry, say your question.
So I don't know. I'm not an attorney. As I've said 100 times, I chose not to be one. Didn't want to go.
Good call.
It was.
Yeah.
I'm still married 43 years to the same person after it because I think I didn't go down that road. It's a frustrating profession. But if you were to get one of these files because you have someone that has come to you and said, I've been wronged, is there anything that keeps you legally, not morally or integrity, because I think you're a moral and integrity guy, but you can't count on that. But legally, is there anything to keep you from making that information public before there is a formal lawsuit filed?
So not under open records, but under discovery rules potentially, and it depends on whether it's a criminal or a civil case.
And that lies, and I was going to make that distinction, but you made it for me, civil and criminal, discovery and law processes. But since you don't have a formal charge, I mean, you're not formally lawsuit, you could say anything you want and disclose anything you want and then go to discovery after the fact, correct?
Correct.
So you could make a public case public and work the press and the public long before there's a formal lawsuit, correct?
That's correct, but I became an attorney to be an ethical attorney because I can't stand most attorneys.
I wish if most attorneys had your history and background, we wouldn't be having this conversation,
Right.
and we wouldn't be in quite the quandary that we as legislatures, with our good men and women in uniform, act. So I do look forward to the resource witness coming back up. Thank you, sir.
Yes, sir. Thank you, Senator.
Senator Birdwell, you're recognized. You have the panel.
Thank you, Mr. Chairman. CJ, I want to, the purpose of the bill is to, you'll understand these terms, I don't know if the other gentleman will, but it's the difference between the 201 file and the local file.
Right. I know what that is.
So,
Even though it's Alpha 2-1 now.
yeah, I've been retired longer than I served, so they changed the names to confuse the retirees.
Right.
But anyway, So the 201 file is a permanent record, local file is kept only locally. So I think that's probably what we're dealing with here in analogy-wise, and that now, the difference is that the local file in a military unit is still an official record, but not permanent record, only for while the individual is in that organization.
And it doesn't follow
So
them.
it's not exactly congruent, the question I'm asking here. But I think, according to Lieutenant Blanchard, and then what I've read from the layout on the bill author is that it's designed for the things that are unsubstantiated. And when I read this list you've given me, are you telling me that this is all unsubstantiated that was hidden, or these are things that occurred, but there may be other things in these folks' files that was not accessible, but also not substantiated? Because I'm the one that had the trucking bill that because what we were, again, not to belabor, but what we had is in the phase one of a trial, it wasn't, what are the facts of this case? It's, hey, you had this violation 20 years ago. That's now evidence that, you must have had this violation now. So it corrupts the phase one of the trial, as opposed to in phase one, if you're found substantiated or guilty, now that history can be brought into the penalty phase, but it shouldn't be in the trial phase.
And
So
yeah.
I guess what I'm asking here is are all of these, I mean, everything from child pornography to DUIs, were these all things that were unsubstantiated in these officers' cases?
So in all of these cases that I brought before you, not all of these have been fully litigated. What I brought you, obviously, were extreme examples. But what I have seen, and the reason I bring these up, because I don't want to go into my personal caseload and potentially expose clients.
Sure, I'm not asking you to.
So I tried to be both vague and a little extremist in the examples that I used. But in these examples, there are underlying allegations that occurred before this person was ever charged that were found unsubstantiated. And then come to find out that there actually was a conspiracy, or this person, it's not his first DWI, it's just the first time that he got caught, even though other people had reported him, hey, this guy's driving crazy, only to find out he was a police officer, and it was never substantiated. That's what I'm talking about, is those kinds of complaints that because each of these has an underlying victim to them, a citizen that is except for the DWI, there's a potential victim, but each of these has a victim. I even included kind of a crazy one here: loafing, sleeping, inattention, and leaving his workstation. These kinds of things likely, and this one I don't know specifically, likely there were allegations before, oh no, he was fine, kind of thing. So, but to a lot of these cases, and I tried to bury the story in the mass so that I wasn't pinpointing any clients. In a lot of these cases, there were underlying unsubstantiated reports that eventually the client was vindicated because the officer got caught later and kept doing it.
Because okay, well, let me finish what I'm, because the underlying pretense, and to Mr. McCain's concern, and I'll ask you a question here in a moment, but is that, innocent till proven guilty. Now, administrative procedures aren't necessarily criminal or civil procedures, so you don't get as high a rigor of formality in those circumstances. But we're trying to afford the police officer the same assumption of innocence that we expect law enforcement and our criminal justice system to assume of the citizen. Let me ask this, Mr. McCain, if I may. Did you file I'm not sure, I assume the word is complaint, but was there a formal complaint against the officer that?
Yes, sir, there was.
That is now in the record, that is searchable, that is not set aside? But, again, Solomon tells us he who speaks first seems wise, till the second comes and examines him. So I only have your side of the story here, not the officers. But is your experience that you detailed in here in your testimony, your written testimony, is that case in an unsubstantiated file in the Waco PD, or is it in a substantiated
It has
file?
been substantiated,
Okay.
and
That
has
would,
been litigated.
that would tell me,
civilly.
that would tell me that as, because, look, given the COVID stuff, I mean, don't like you having to go through this, but that would tell me that the system worked for you, that you had an experience that was not just unpleasant, but outside the bounds of what the officer should have done. As a citizen, you filed that complaint, I assume, with the police department.
Correct. It was, I filed it with the interim police chief.
Okay.
Actually, the assistant police chief, but it was difficult in order to file the initial complaint. And the information that I was able to obtain showed that the responding officers, the commanders and sergeants, tried their best to put the officer that basically assaulted me favorably.
Okay. Let me ask this. The way you said that is, in making the complaint, did you try to access previous events to substantiate your complaint, or did your complaint stand on its own with the facts specifically of your experience from walking into that convenience store to being arrested and then filing a complaint? Because I think what I think the bill's trying to do is kind of like my trucking bill. The complaint ought to be based upon the experience with that officer, not taking, if you were, convicted of murder 20 years ago, get out, and then there's a murder and you're charged with it, does the fact that you were convicted 20 years ago mean that you're guilty now? The answer is no. So it would be appropriate that if and you've told me that your case was substantiated, then if you wish to civilly litigate it in some way for damages, then at that point, that other information may be relevant to a penalty phase as opposed to the guilt or innocence of the officer. Is that fundamentally what I think you're trying to express to me? That
Yes, and I filed the complaint, then I researched it throughout this time period, and I was able to get the officer's civil service personnel file. Not the one that the police department carried. And in that civil service file is where I found other issues or issue with this officer previously.
okay? And is that civil service file held by CLEAT, TCOL, or was it a completely different public service organization besides the police department of Waco?
Local.
Yeah, I guess it's been 5 years since then, but
Okay. Okay. Let me ask, Lieutenant, if I may, are your most effective officers, and I have not defined what the definition of effective is, but are your most effective officers the ones with the greatest numbers of complaints because of their effectiveness? Or is the numbers of complaints against an officer not statistically relevant to how successful they are in whether it's patrol, homicide, whatever their particular division is?
There is a direct proportion to the number of citizen contacts an officer has versus how many complaints they get. Now, that is not indicative of misconduct. That's just indicative of their activity. Right? It is possible to be an officer and go through your entire career and not get a complaint. That's a great officer, right?
Okay.
It is also very easy to have a few citizen complaints and every single one generates a complaint, right? I don't think, to your question, I think that yes, you will probably get complaints if you're a active officer and you're enforcing the law.
Okay. in a department as large as yours, I would assume, internal affairs does every department have somebody that's checking the validity and the veracity of, or is there an independent, and I say independent of the department's authority, that is checking the veracity or sustainability, not sustainability, that's not the right word, but the verification of a complaint?
So I can speak to what we do. We take a complaint when we preliminarily review it. If we can review body-worn camera and verify that it just didn't happen, we clear the complaint. If we don't, and we still have the complaint that we weren't able to verify that it was false, we will start an investigation, and then we will determine whether there's enough evidence to sustain.
Okay. Who checks internal affairs?
We have a civilian oversight board that we work closely with.
And how are they made up? Are they
They
appointed by the mayor? Are they appointed by, how do they?
Each council member appoints a board member, and we also have an office of community police oversight that works closely with our internal affairs division and reviews our investigations as we do them.
Okay, all right, thank you.
Senator, can I make one quick, and just a legal aspect of it? One of the reasons why it's important, because there's something called Monell liability. I don't know if you know what that is, but if I, as a civil attorney, want to sue the county or the city or whatever that entity is, I have to overcome what's called Monell liability. I have to show that there's a policy, practice, or procedure. And that policy, practice, or procedure would show an act or an omission of an act. And so I would need to know, okay, that's why it's important to know, is there a policy, practice, and procedure to allow all these things and find them unsubstantiated? Because then I know when I've got my litigant that comes to me, am I only suing that officer, or am I also suing the county or the city or the school district or whatever it is? And so that's where the unsubstantiated stuff comes in, because it helps us to determine whether or not there's Monell liability.
All right, thank you. Thank you, Mr. Chairman. Thank you, members.
Thank you, Senator. Thank each member of this panel for your testimony. Thanks for being here, and you're excused.